Good morning. Can anyone hear me? Good morning.
Môre member, ons kan nie hoor. Baie duidelik. Goeiemôre almal. Good morning everybody.
Good morning. Good morning, Honorable Dennis. Thank you.
Morning. Good morning, everybody.
Good morning.
Morning all.
Morning.
Morning.
Good morning, everyone.
Morning, Ms. Khan. Good morning all. Good to hear from you and I'm looking forward to a good meeting.
Honorable, good morning, honorable members. Yes, can I take this opportunity to welcome you all and saying that starting from today until Sunday, as you have seen in your program, we are having a very tight program. Who's Arthur? Who's, I don't know who's speaking. I'm saying as from today until Sunday, we're having a very tight program. I'm hoping that honorable members are ready. But now I'm taking this opportunity to say that I'm opening this meeting officially. Can so give us apologies.
Thank you, Madam Chair, and good morning to you. Good morning to members of the committee. Good morning to Madam Deputy Minister and colleagues on the platform. We only have one apology, Madam Chair, which is the standing apology of Mr. Mamabulo. Thank you, Madam Chair.
I do have an apology, which the Office of the Minister say they did forward, but let me tell you, official Minister is in the cabinet meeting. I'm having that apology. And then may I have hands with I'm seeing Honorable Adams's hand. I wanted to say I want somebody and members to adopt the agenda. Honorable Adams.
Sorry, Chair, for doing that, but I have the notice that Honorable Sabia also apologize. I thank you. And I move for the adoption of the agenda. Thank you.
The apology of Honorable Sabia. Honorable Adams move for the adoption of the agenda. I'm seeing Honorable Mteto. Honorable Mteto.
I second the adoption, Madam Chair.
Thank you, Honorable Mteto. The agenda has been seconded. Now, Zolega, please don't take it out for so long. Today, I was messed up. I didn't write it down, the agenda. I usually wrote down. According to the next item, responses to oral and written submission by the Department of Arts, Sport, Arts and Culture. We are in that. Now we are in point 2. Can now to the department. I'm seeing my Deputy Minister.
Chair.
Yes,
Chair. Thank you so much. Thank you so much, Slalo.
You are welcome, DM. Thank you so much. Your department has been part of all what we've been doing. And we are aware that when you were not here, they did, or they always reported to you as a collective. We are giving to you now at DM as we are leading the department.
Thank you so much, Chair, and good morning to the honorable members and the officials that are in the meeting. And thank you so much. I thought I was going to be late, Chair, because I had to start quickly at the cabinet, but at least I made it on time. I'm very grateful to be here, Chair. And I just want to first, before the officials come in to give the responses, to really, really appreciate the work that has been done by the committee led by yourselves in this work, Chair. When the SAIDS, which is the anti-doping agency, received the non-compliance report or the finding in September of 2023, most people thought that it was really a sad day for the sport in the country, because what that meant was the effect that we can't host international bodies, but we also wouldn't be able to hoist our flag in the international competitions. But when we knocked, to yourselves and came to you in December, I remember that portfolio committee of December was just at the door of the recess. But you put everything aside and you rearranged your schedule, your meetings, to make sure that you deal with this amendment of the legislation. We've got no words as the department, I'm sure as the sporting family in the country, of the work and the appreciation of what you have done as this committee. I don't doubt it, Chair, that this will go down for a long time in the history of this country. What the portfolio committee led by Chairperson Putulane did at a time that we needed it the most. So we come before you now to respond, and we have absolutely no doubt that at the end of this process, we will produce an amended legislation that meets the standard of WADA, and therefore the sporting world, and we will be able to see South Africa back again. So we just want to say thank you so much. As I'm handing over to the officials, the minister said I must really, really, really pass this message of appreciation to the portfolio committee. The way you have worked together in this, the way the entire members of the committee put everything aside and said, this is us, this is our country. Thank you, thank you, thank you. I'm going to hand over now to the officials of the department. Thanks once more, Chair.
Thank you, GM. You are echoing our words that the department also did take a very good initiative when we were nearly not able to put our flag high. And then, as we are saying, honorable members, they are aware that what we are saying, have been saying to themselves that even whilst we are in the era of doing election, looking at the list, honorable members, they are aware that the term is not yet finished in the list or not in the list. They prioritize this work. Can I give it maybe to the person who have been with us? I'm suspecting she was leading the what you call the entirety from ministry, but let me give to anyone whom the department has that must present. We've been with you, DDG, Sumaya Khan, so we do appreciate all of you who have been, whilst you were not in here, not to participate, but to listen for your department. You have been with us. Advocate, you have been with us. I can't say anything about our staff who were like ourselves, not sleeping, waiting what Chairperson on behalf of the committee is saying, and you were running like any task. Can I give it to the department, somebody who's going to take us through? We are listening. Say it's also, they've been not taking chance They've been with us all the time. Thank you, DM, and somebody who's given the responsibility to take us through.
Good morning, Chairperson, and good morning, honorable members. Good morning, Deputy Minister and colleagues. Chairperson, thank you very much for the opportunity, and we also want to echo the sentiments of our Deputy Minister and express our appreciation and gratitude for the manner in which the Portfolio Committee and the staff that support you have conducted themselves to get us to this point. Chairperson, we appreciate also the inputs that the legal services have made yesterday into the various clauses of the bill. What we've done, Chairperson, is we've taken the same document, looked at the same clauses that were there, and we've then made our own comments based on that as a response, Chairperson, that is expected of us as a department. So, Chairperson, I have put up this presentation, excuse me, and you'll see that, clause by clause, whatever was proposed by the legal services, we've either enhanced it, or where we've agreed, we've said we agreed, and where it's not applicable, we have indicated that on the document. Chairperson, I want to hand over to our senior legal admin officer, excuse me, Mr. Benedict Mukubedi, who's going to take us through this document in detail so that the Portfolio Committee will be able to see, all the inputs that came from the different stakeholders, the inputs that they made, the recommendations that they made, and also what proposed amendments came through, their own inputs, and then what we have now indicated as well. So, Chairperson, with your permission, I want to hand over to Mr. Benedict Mukubedi, who will take us through the document itself. Thank you, ma'am.
Thank you,
With your
DDG.
permission, Madam.
Yes.
With your permission, Madam Chair. Thank you. Good morning, Madam Chair. Good morning, DM. Good morning, honorable members on the platform. First, I will also like to echo the sentiments to the effect that we've appreciated the support that has been rallied against this particular endeavor, and the submissions that have came through, even though some of them are not necessarily going to find their way into the bill, but we've appreciated the effort and the enthusiasm, and even those that did not make submission, but the fact that they did, however, support the process, we appreciate that. Without wasting much of time, I know that the presentation, I have 30 minutes, so I'll try to confine myself to those particular time constraints. DDG, if you may assist me with the scrolling, I'd appreciate that very much. Now I'll start with clause 1, which dealt with the definitions. The first one that was warranted was with regard to the anti-doping organization. The insertion of that particular definition was included in the definition of the amendment bill, which meant that anti-doping organization will be defined as an anti-doping organization as defined in the Appendix 1 of the code. The reason we are defining this particular definitions, like all the other ones making reference to appendix of the code, is so that even if they do change, we don't have to come back and find ourselves in the same position that we find ourselves in right now, because when they change, when the code changes, ours is just to make reference to that particular code. So that particular recommendation, which was also submitted by WAD as well as SAIDS, was effected. We've also received a submission from CASETA, wherein they proposed the definition of of sports to be included in the definition of sport to be included in the definition clause. We felt that the word sports conveys its ordinary grammatical meaning, and in line with the drafting standard, you do not define words unless if they carry their ordinary meaning. You see, if sports meant something else, then you would be compelled to then define it. Of course, we understand why they would have warranted that, but again, we had to be confined to legislative drafting style 1, 2, also not to create other inclusions that may cause issues with one. So we went with the safe option as well as legislative guiding principle. So that is why we were of the view that the definition of sports should not be defined in the definition clause of the bill. Then we also had Free State Academy of Sport, where they advised that we should consider the inclusion of reference to the POPI Act, which is a very important piece of legislation that has been developed by our country. Members should note that legislations like POPI, as well as even the Constitution, even though you do not make reference to them because they are laws of general applications, whether you insert them or do not insert them, you are still obliged to comply with those particular pieces of legislation, because in the drug-free sports sector, but as I've stated, it's a law of general application, so therefore it applies generally. So we felt that we do not need to conflate issues on the bill, as long as we know that this particular piece of legislation will be applicable nonetheless. Thank you. Next slide. Okay. The other proposal was that the International Paralympic Committee has indicated to SASCOC that they should effect their name change to be inclusive of parasports in South Africa. We've noted that particular submission, and we've amended our the word SASCOC will be replaced with Sports Confederation instead of SASCOC, to cater for whatever names that SASCOC will have, even if it includes parasport or Sports SA or whatever name that they would come up with. We are of the view that the term Sports Confederation will cater for that. So that will be covered in that aspect. It was a good suggestion, and we felt that Sports Confederation will cater for whatever names that will be made. Thank you. National Treasury made submissions as well, noting that SAIT is a Schedule 3 entity or listed in the PFMA. So their submission was that the words in terms of the Public Finance Management Act should find should find themselves in the definition of what is SAIT. That particular submission was accepted, and the bill was amended accordingly. Next slide, please. Please. Yes. Excuse me. Yes. No. Okay. Yes. Says may submission that the wording in the bill, okay, clause 10 dealt with the objectives of provided to promote and ensure the adoption of doping control, which may subject any athlete to testing.
We're having a problem now with your
or without
Benedict Tim. Now we can't hear you
Now,
clearly.
the issue here was that if this particular provision in the encompasses the word with or without, states felt that it may lead to misinterpretation to the effect that okay, apologies for that, Madam Chair, it must be connection. But from where I'm sitting, I'm not sure if the rest of the colleagues, members on the platform can hear me, because you yourself, Madam Chair, when you were responding to me, you're breaking. I'm not sure whether it's on my end or just for clarity's sake.
But now we are clear.
Is everybody having the same challenge with me?
But now we are just clear you then. But now we do hear you. But when you were about to finish a clarification on the Public Finance Act, we started not to hear you clearer, and it was worse when you are tabling this clause 10. So, but now just now we are clear. I don't know, maybe really it's because of in-network. Go on. Go on now. Honorable members, DG, what's going on? DG?
Chairperson, I'm trying to contact Benedict to see what his issue is. Otherwise, we'll have to take it through, present it while he sorts himself out. He's not responding to his...
Just continue, whoever was having that document.
All right. No, fine. Chairperson, let me continue with section 10. The wording in the bill implies that, it could lead to interpret that athletes have a right to advance notice. Now, in the testing field, you don't give advance notice except in exceptional circumstances. So the recommendation was that, and this came from SAIDS themselves, the recommendation is that we delete the entire paragraph, which reads that promotes and ensures adoption of a doping control program, and it may subject any athlete to testing with or without advanced. But the whole idea is not to give advance notice. So the proposal is that we replace it with a clause that says the objectives of the Institute are to promote and ensure the adoption of a centralized doping control program, which focuses on implementation and implementing intelligent testing, both in competition and outside and out of competition. I'm trying to get down here. On athletes over whom it has authority. So that's the proposed amendment, and Chairperson, as a department, we accept this and we will amend the bill, amend this clause in the bill accordingly. Okay, if I have to scroll down, And we go to the next one. This is again also clause, the same clause. We had input from the South African Rugby Union, and they had asked for certain clauses to be amended to include the National Sports Federation. And the proposal was that we include them in. We've looked at this very carefully, Chairperson. We noted the point, and we believe it's an administrative process, and it is already covered in the standard operating procedures of SAIDS. So that has been addressed, Chairperson. And then the same clause, we got the input from the Free State Academy of Sport in terms of specialists and experts in the field that may be in the sports performance institutions. These are your high performance centers, these are your academies, and they have proposed that it will be of value to the national effort and to keep sports clean if we include them in the bill as well. Again, Chairperson, we believe it is not applicable because it's a very administrative thing, and we don't want to cloud the bill with too many new things because we're looking at a lean bill, something that's easy to implement and something that is compliant. So we've not considered putting that into the bill, Chairperson. Okay, I want to move down, Chairperson, into section 11, the powers and duties of the Institute. And here it came from SAIDS, and they're saying that under section 11 of the Act, there is no need for substitution of paragraph 1 and 2. And they're saying leave the wording as it is. We should not be removing the words registered testing pool because this is the correct wording for reference to top level athletes. The wording, the proposed amendments at the wording contained in section 11.2.1, that is establish and maintain a registered testing pool of top level athletes who shall be subject to both in competition and out of competition testing, remains unchanged. We've accepted this, and we've not made any amendments to the bill where this area must stay. So whatever amendments that they are proposing here, we have now put that into the bill, or recommended it for the bill. Okay, the other issue from SAIDS was SAIDS has not just a registered testing pool for top level athletes, but it also has other categories of testing pools. For example, there's a testing pool that exists for sanctioned athletes. So SAIDS and WADA had proposed a substitution of paragraph M subsection 2. So the only change here was singular to plural. Instead of testing pool, you have testing pools, which is more than one, the plural. So in line with our comments there was that in line with the legislative drafting style, one usually drafts in singular. However, the recommendation is accepted and the bill is amended accordingly. Chairperson, we go now to section 11 of the bill. There was no comments coming through from any one of the contributions that we received, and hence there was no recommendation. So this is not applicable in terms of any amendments. And then we go to section clause 6, which is section 17, the appeals. I'm not sure if Benedict is back, Chairperson, because if he is, I know this act, the most amendments and the most discussion we've had was around this act. And even WADA, Chairperson, had indicated, that this act, this section was non-compliant. Even as recently as this week, they were indicating that even some of the proposals we are making may not be compliant. So I know Benedict worked very hard on this together with WADA, together with SAIDS, and also with the legal advisor in Parliament to review this and look at how do we then craft it to make it compliant. I'm not sure if Benedict is in the meeting again and we can hear him.
Let's try him. Benedict, are you back?
Madam Chair, I am back, hopefully for good this time, and hopefully that I'm clear and very audible. Am I?
Yeah,
Yes.
you're audible. Yes. Yes.
No, thank you. That's correct. The task of the non-compliance provision mostly resulted with this particular provision where WADA emphasized the independency of both states as well as the appeals board. Now, I have to also submit that the department had been liaising with the Parliament legal officers as well as state legal officers. I beg yours. And we were able to craft a provision in line with the submissions that would have been made by states as well as WADA. And we are of the view that without over promising that am I breaking as well? Am I still?
Yes, you are, but you are not as bad as the previous.
I'm comment by the DSEC. Here, what we try to do is actually provide an entirely amended section 17.
Chair, I'm hearing that he's struggling again. Yes.
Yes, I think Sumaya and the team must intervene. Benedict is not the only lawyer.
Yes.
What you are now seeing on your screen is the amended clause 17. And
can you start
because also as I've stated,
sorry, Benedict.
the point of contention was the minister appointing
Benedict.
No.
Let me phone
Benedict. You were not audible. We are not sure what we.
I can hear you loud and clear. I can hear you.
No,
listen. Can't hear you.
I can hear you loud and clear.
That's not the point. We can't hear you loud.
Listen. We're saying that we lost you, and then now you are back. You still have the same problem. We're not saying that we didn't hear you in the whole presentation, but in the middle, you were again not audible. And even when I'm trying to call you, your office trying to call you, you couldn't hear because you have a serious problem. We don't know what to do because you are very important in this clause. Can you try again? Start it afresh.
Okay.
But Chair, he is not the only legal person that is here.
That's
there
the thing.
Yeah, no,
there is Arthur here, so Sumaya must intervene.
Okay, no, thanks, Chairperson. Thanks, ADG. I'm not sure if Mr. Mantata is here, he can do it. But let me also then let me comment, Chairperson, to say that, yes, this area of work was the most contentious in how the appeals board is constituted, the objectivity around the board and those persons who have to oversee where there are areas. So Chairperson, I'm going to what the team has done. They've looked at this whole clause and they've rewritten it to make it as compliant as possible. So what we have here, Chairperson, in this presentation is the whole new crafting of Section 17. And if you look at it, if you look at all of it from the first column, where what has come, what was there, what SAIDS has initially indicated, and SAIDS has indicated that it deals with appeals. It's a major part of the draft bill. It makes SAIDS non-compliant again. They already provided, and what SAIDS is saying is, they already have a procedural provision of appeals in its anti-doping rules of 2021. It has operational standards for appeals hearings. They have rules that guide the process, and it is not necessary to have what is contained in the bill. Again, they're saying it has never happened in the history of SAIDS that the Minister of Sport has appointed who gets to chair or adjudicate at the SAIDS appeals hearing. And they say they always made use of an independent person that has no conflict of interest in sports. They have been referred to as a registrar, and they also indicate that 17.2c, in 17.2c, they must note that the last appointment of the appeals board, the members made by the minister are from the minister's office, were not in accordance with the legislative requirements. But Chairperson, what we've done here now is they've proposed how the bill, how that section 17 is crafted as well. I'm just moving because it goes through many pages on each column. So the proposal from SAIDS was that the proposal of a minister and SASCOC's involvement is in direct conflict with Article 13 of the SAIDS anti-doping rules. But obviously, for us, the rules come out of a legislation. So obviously, any rules will have to align itself to any new legislation that comes. So you can't change legislation to suit rules. So section 17.3 and 4, there's no need to insert into the bill substance and procedural requirements. This is already provided for in the anti-doping rules. The operational standard for appeal hearings and the WADA international standards for result management. They're also saying that section 17.5 as above, there's no need for the minister to be involved in administrative matters that will delay the processes. They're saying there's no need for the institute to be writing the appeals procedure. There's no need for the minister to be spending her time giving guidance on administrative matters that are not within the expertise. And they're also saying that section 17, the word doping cannot be used. And they are requesting that the insertion of 17.2 and 17.2 that was proposed by SAIDS and approved by WADA be reconsidered. Now, Chairperson, the legal committee from the legal advisors from Parliament in their responses had indicated that we must remove section 17.2a. We must remove the whole section 17.3 and 17.4 and the whole section of 17.5 and 17.8. They are proposing that we insert a section 17.2 which speaks about results management shall be the responsibility of and shall be governed by the procedural rules and anti-doping rules as amended from time to time in accordance with the code. And the results management under the anti-doping rules establishes a process designed to resolve anti-doping rule violation matters in a fair, expeditious, and efficient matter. And insert 17.3, the Institute shall establish a hearing panel, names the Independent Doping Hearing Panel, which has jurisdiction to hear and determine whether an athlete or other person subject to the anti-doping rules has committed an anti-doping rule violation, and if applicable, to impose relevant consequences. Now, Chairperson, we have looked at it as well, and we've engaged with the parliamentary legal services as well, and we've also engaged with WADA themselves. So this is our input, Chairperson, that the whole section 17 is called result management. And 17A1A, we are saying results management shall be the responsibility of and shall be governed by the procedural rules and anti-doping rules of the Institute. aligned with the principles of the code and relevant international standards. In that way, you're not getting into details, but so if the rules change, if the code changes, all of this doesn't have to change because you are saying it will be aligned to the principles of the code and the relevant international standards. Then we're saying the institute shall establish a first instance hearing panel named the Independent Doping Hearing Panel, which has jurisdiction in the first instance to hear and determine whether an athlete or other person subject to the anti-doping rules of the institute has committed an anti-doping rule violation, and if applicable, to impose relevant consequences. This independent doping hearing panel shall conduct the hearings and decision-making process without interference from the institute or any other party. Then section 2A, 17.2A, there is hereby established an independent board which shall be known as the Anti-Doping Appeal Board, with jurisdiction in respect of decisions made under the code or the institute's anti-doping rules. And then, Chairperson, the minister shall appoint an appeal board which shall consist of not fewer than 9 persons possessing special knowledge and expertise relevant to anti-doping and dispute resolution. The members of the appeal board are appointed for a period of 5 years and are eligible for reappointment. The appeal board must consist of no fewer than 4 practicing attorneys or advocates, 2 sports medicine physicians, and 2 sports administrators. The appointed members of the appeal board shall be operationally and institutionally independent from the institute. The minister may terminate the appointment of an appeal board member for serious misconduct, incapacity, or incompetence. A party to an appeal shall be entitled to be represented by a person of his or her own choice. The procedure to be followed in connection with appeals shall be determined by the appeals board. A member of the institute and a member representative from a national sporting federation in respects of its member athletes shall be entitled to attend any hearing of the independent doping hearing panel or appeal board as an observer. And then the appeals involving international level athletes shall be heard by the Court of Arbitration for Sport in accordance with the relevant provisions of the code. So, Chairperson, I want to pause there and see if there's anything anyone wants to add from the team, because it's a very long provision. It's an amendment, a total amendment of that one section. And then you'll see, as we go along with the other inputs, it's not as detailed as this one, Chairperson. I'm not sure if Benedict is here and he can hear, or Mr. Mantata, if they can also make any comments around this input from DSAC, Chairperson.
Okay, they are here, they are listening. Any one of themselves who have got a good reception. We apologized. Yesterday it was myself who was having this problem of network. Anyone from these 2 gentlemen, they must take it over and say more things in this. I'm suspecting it's the most section 17. Any one of you?
I'm not sure.
Good morning, Chair.
Morning.
Arthur Mantata.
Yes,
Yes, good
Arthur.
morning, DM. Good morning, other honorable members and colleagues. Yes, this was the most contentious clause in the bill, and as a result, an innovation was made that there must be 2 processes of first the hearing of first instance, and secondly that there must be an appeal body, which in this case may still be appointed by the minister. And if this clause all parties now agree, if this clause now all parties agree that it will make the bill compliant, I think most of other clauses
Typical Jolly
of
DSAC.
the bill.
Myself who has got something speaking behind you.
Yeah, my computer speaks, so that's why it keeps on coming in. As people join in and out, it reports. Okay, but I'm about to make to finalize my comment. So if this clause is now agreed upon by all the parties, including ourselves, states, and all other stakeholders, I think the bill will now be compliant, and hopefully now we can present a bill to the portfolio committee that all parties agree that it is compliant and we can take it forward from here going forward. Thanks, Chair.
Thank you so much. DDG, is any other thing that you didn't say as a department, in order that now I must give it to the members?
Okay, Chairperson, there's just a few more clauses. I'm going to just go through it. It's not as large as this. There is some information there. So I just want to take us through that. If I just go down the presentation, you will see that, there was an input also into 17.1a and 17.4a2. I think the fact that we've rewritten a lot of the bill has covered a lot of things, but in this one, it's very specific about the TUE committee review, and the TUE is the application, and then depending on the findings, and the appeal board must grant or either denies the TUE, and if that is the interpretation and practical, they want to know what are the regulatory steps. And we're saying here, although that is covered in Article 4.4 of the SAID's rule, so there's no need for us to look at that in the actual bill. And then they are also proposing an amendment to Section 17C in terms of, a member of the National Federation in respect of its members as well as members of the Institute. Will they be entitled to attend any hearing of an appeal as an observer? I think we've indicated that we noted, we agreed. However, we have resolved to omit the procedural provisions relating to appeals from the bill. The procedures will be determined by the appeals board. And you will note, Chairperson, we've given a very detailed explanation of what the appeals board will do in this previous input that we've made, the bigger, more detailed input. And then National Treasury had indicated, issues around the fact that, there must be budget for everything that is being done, especially around the appeals. And we've indicated that we've noted it, and the budget for the appeal is provided for by the South African Institute of Drug-Free Sport within the budgets that they have. And then Bodybuilding South Africa also indicated some areas that all appeals should be heard by the appeals board, and only if the person is aggrieved by the outcome should they go to CAS, because the CAS process is very expensive and not even international athletes can afford to litigate at this forum. So we are saying we noted it, and we said appeals involving international level athletes are heard by the Court of Arbitration for Sport in accordance with the relevant provisions of the code, but also the Court of Arbitration offers legal aid. And we've also indicated that the new Clause 17 provides for results management as well as the appeals process. So I think that responds to that query and that challenge or that concern from bodybuilding. In terms of Section 17A with punitive measures, we believed it was not applicable. That came from bodybuilding as well. And in terms of, again, the stakeholders question the phase as it deems fit. And this implies that SASCOC can then use whatever process they want to conduct an investigation. And the stakeholders' recommendation is that It must be fair, transparent, just, and equitable. And we are saying the proposed amendment that came from us, from the Legal Services at Parliament, was saying the department, on the written recommendation of SASCOC, may cause an investigation to be conducted in a fair, transparent, just, and equitable manner to ascertain whether all national sports federations have complied with the provisions of the Act. And we are saying that we accept the recommendation from the parliamentary legal team, and it will be included in the bill. And then, Chairperson, again, Section 17A, there's an issue of the sanctions again. Only if the association is to be found non-compliant. And then they also indicating how it must take place, very operational things there. So we are saying the parliamentary committee is saying the department must, after consulting with the Institute and SASCOC, and after any national sports association is found, after an investigation is conducted as contemplated above to be non-compliant, identify any non-compliant national sports federations, whereafter it may, amongst other, do a whole lot of things. And we're saying we accept this, and the bill is amended. And we're saying regarding the comments on 17.2a, clause 3, provides that the department may only act against a federation in terms of subsection 2 after it has given that federation an opportunity to make oral or written representations with regard to any proposed action. We're also saying that clause 17A3 is necessary to justify the punitive measures in clause 2. Okay. And then the Free State, they've asked about federations not in good standing with the National Federation or the Provincial Confederation. Will the athletes still be allowed to participate in events independently from the federation? And if the federation is barred from administering its sport, they noted that they would not want athletes to benefit from their services and support if the federation fails to comply. And we believed here, Chairperson, that this was not applicable for this bill. And then again, clause 8 is about the title. We find recommendations accepted, and the bill will be amended where the recommendation is proposed to provide for appeals, to provide for punitive measures in the long title. And we said, and they're saying appeals should read appeals hearing, and we find with that. In clause 9, there were no comments, so there's no, so it's not applicable in terms of our own input. Chairperson, there we are. We've concluded on our input into the various clauses. If there's anything else that the colleagues want to add in over and above what I've indicated and what Benedict has also attempted to provide, I think he was doing well at the start, and also what Mr. Mantata has said. If there's anyone else from the department who wants to make any other comments, please can you quickly make those comments as well so that we can hand back to you, Chair.
Honor, did she?
Okay. Anyone? Okay.
Hello.
Okay, Chairperson, I'm not seeing any hands from outside. So can I hand back to you, Chairperson?
Thank you so much. Thanks so much, DDG. As this committee who have been part of all what you are responding on, whilst the crux of the matter is section 17, but I've seen that even those other section or those other input, the responses are here. But now, before I give members, can I give our advocate who has been with you and with us. I'm suspecting from there we'll be having just not too much of questions, because when I'm listening to you and the members listening with other sections, you have touched and responded. This now time, can I give it to you, Ms. Arnold, to take the platform? It can assist us if we're doing like that.
Good morning, Chair. Good morning, honourable members.
Morning.
And to my colleagues from the department, I hope I'm praying that I'm audible throughout. The network seems to be a bit unstable this morning. Nevertheless, as our DDG has explained the amendments that need to happen in order to make our bill compliant. Most of the proposed amendments we have captured, Chair, and the first amendment relates to anti-doping organization that has been included. Sorry, Chair, before I go on, I just want to indicate that we've also done an extensive exercise where we have confirmed whether we need to make any consequential amendments, and we've then gone through that process to see, okay, because we are adding in, for example, section 17, would there be any consequentials, or specifically we are now using the word sports confederation instead of SASCOC, so we have attended to those consequential amendments as well. We've also any drafting errors or spelling errors where we have picked those up, we have fixed them so that we can produce the best, not only a compliant bill, but the best version of the bill. And I think that is all of our objectives on this platform. So clause 1, Chair, we've inserted the definition anti-doping organization, Chair. We've also redefine the word sports confederation, and that is in line with the change from SASCOC. They are in the process of changing their name, but the reference to the sporting confederation is a much more general term. Chair, we've also importantly, and this is a nice provision which we have come up with together with the department and SAIDS, is in section 1. Section 1 now not only deals with definitions, but deals with the interpretation of this act, of the South African Institute for Drugs-Free Sports Act. So we've included a provision which says that when interpreting provisions of this act, any reasonable interpretation which is consistent with the code must be preferred over any alternative interpretation which is inconsistent with the code. Chair, so the purpose of that is that should WADA in the future come back and say, once this act is enacted, and say, oh, your act is inconsistent for so-and-so reason, we have this interpretation provision which is saying, look, let's interpret this act in line with the code. That is the objective of this act, Chair. And then clause 2, as the DDG indicated, we've taken on board the inputs from National Treasury. This doesn't touch on non-compliance with WADA. However, we've listened to what National Treasury has said, and we have included the reference to the Public Finance Management Act. There was one submission by WADA where they said that we need to, where we use the word republic, we need to refer to clarify that it's the Republic of South Africa. Now, ordinarily, Chair, we won't expand in that manner, because I mean we all understand when we say republic, it's a Republic of South Africa. However, we thought let's not split hairs and let's take on board WADA's recommendation to say Republic of South Africa. There's nothing wrong with doing that. Then clause 3, Chair, amend section 10, and as DDG Sumaya Khan has indicated, we've fully taken on board WADA's proposal and SAID's proposal, and the proposal that they have made, it is legally sound and constitutionally sound, and will also ensure compliance, Chair. Then clause 4, we've again listened to what SAIDS was telling us and what WADA is telling us, and this is with regards to making our bill compliant. So essentially, there is no need to amend Section 11(2) of the Principal Act, and this was captured in the introduced bill. So we are not amending any longer Section 11(2)L. Instead, we have made an amendment to Section 11(2)M, and the only amendment there is to refer to testing pool instead in the plural as opposed to the singular. So we have captured that, and that is legally sound and will ensure to contributing to the compliance of our bill. Chair, there was also another amendment with regards to instead of referring to, and this is to the therapeutic use exemptions, Chair, it should be exemptions with a plural S. So Chair and members, as we can see, it's very detailed and very technical, some of the proposals that WADA has given, but we have gone through it and we sort of done a tick box exercise to try and ensure, even though it's a S and it might seem as non-consequential, we understand what WADA is saying, and we have, instead of just referring to exemption, we have referred to exemptions with a plural S. Then, Chair, we come to clause 6, and this is this is where majority of the issues raised with regards to the non-compliance of our bill. And SAIDS and WADA's input was basically that, look, when you are dealing with the appeal board, and previously in the introduced board bill, we had a reference to the appeal tribunal. So we had the appeal board and the appeal tribunal. WADA and SAIDS was telling us that we cannot have heavy procedural provisions. We also should ensure institutional independence between the institute and the appeal board. So we looked at we read SAID's rules. We read WADA's inputs on the introduced bill, and we basically, instead of just referring to the appeal board, because in essence, it's not just the appeal board. There is a first step hearing panel, and that is the independent doping hearing panel. And that is actually the tribunal which was referenced in the introduced bill. However, it was causing a bit of confusion. So the redrafted clause, section 17, just highlights that we have this concept of result management, and under result management, we have the independent doping hearing panel, and we have our appeal board. But before you even worry with the appeal board, you would first, you have this resolution option of going to the independent doping hearing panel. And in the bill and in the redrafted clause 17, we say that results management is governed by the procedural rules and the anti-doping rules of the institute. And the principles of the code and the relevant international standards, right? Then the institute will establish as a first instance hearing panel named the Independent Doping Hearing Panel, which has jurisdiction in the first instance to hear and determine whether an athlete or other person subject to anti-doping rules of the institute has committed an anti-doping rule violation. So you have this Independent Doping Hearing Panel, which athletes would go to first, right? And the decisions which the independent doping hearing panel can make is in accordance with the anti-doping rules of the institute. Chair, honourable members, the SAIDS, the institute's anti-doping rules, sets out fully and adequately everything that this independent doping hearing panel can hear and what they can decide. And as WADA has indicated, we cannot and should not have such heavy administrative detail detail in our bill. Then the next point that we've incorporated in the redrafted clause, section 17, is just to indicate that the independent doping hearing panel must conduct the hearing and decision-making process without interference from the institute or any other party. And this touches on the need for institutional independence between the IDHP and the institute and from any other party. And I think this is not only something that WADA is explaining, but I think it's a standard and a concept that we can appreciate in our South African context as well. We need independence. We need panels, we need bodies to make decisions without interference, and that goes to fairness, and that contributes to constitutionality of this bill. So now we've nicely sketched out our IDHP. We then provide for the establishment of the Anti-Doping Appeal Board. And this appeal board is established by the minister, which shall consist of no fewer than 9 persons, and these persons must have special knowledge and expertise relevant to anti-doping and dispute resolution. And the members of the appeal board are appointed for a period of 5 years, and they are eligible for reappointment. We then just, for the purposes of clarity, indicate that the appeal board must consist of no fewer than 4 practicing attorneys or advocates, 2 sports medical physicians, and 2 sports administrators. And then, most importantly, Chair, I'd just like to highlight we've included that the appointed members of the appeal board shall be operationally and institutionally independent from the institute. So again, as we see with the IDHP, the appeal board needs to be institutionally independent, and we are reiterating this in our bill. And I think that this is also what WADA has indicated, that you need to ensure institutional independence. And then we've also just highlighted the grounds whereupon the minister may terminate appointments of appeal board members, and they are for things such as serious misconduct, incapacity, or incompetence. And we've then also highlighted that a party to an appeal shall be entitled to be represented by a person of his or her own choice. And the procedure that the appeal board is to follow will be determined by the appeals board. Chair, honourable members, this ties into institutional independence. It's not the institute that will tell the appeals board do X, Y, and Z. It is the appeals board itself that will determine its procedure. Chair, with regards to we've also indicated that people can sit as observers on the independent doping hearing panel or the appeal board. They can then sit as observers. Chair, this is one sticky point that we're still trying to figure out, because it is the sitting as observers is in fact covered as under the Institute's anti-doping rules. So we just want to make certain, and the question that we're asking ourselves, whether it's necessary to include the sitting of other individuals on independent doping hearing panel or appeal board as observers. We've left it in for the moment, Chair. However, we just need to double check whether it is necessary. And the question we're asking ourselves is whether this would be deemed as an unnecessary administrative step. But we have it there, and the department has presented it there so long. But like I say, Chair, we will just double check whether it is in fact necessary. And then the last part of Section 17 is just to confirm that international level athletes can be, their matters will be heard by CAS, the Court of Arbitration for Sports, in accordance with the relevant provisions of the code. Chair, that is Section 17 of the redrafted, the redrafted Section 17. And then 17A, we have listened to what Bodybuilding South Africa has told us, and they have asked for fair, transparent, just, and equitable manner that that decisions are made in a fair, transparent, just and equitable manner. And there's nothing wrong with their submission, Chair. We have taken that on board and come up with a way as how we can include it in section 17A. And then also just that when the department makes a decision with regards to these punitive measures, that decision, and this I think it goes to logic, that decision can only happen after a finding of non-compliance has made. I think the department had ordinarily, they would do that. However, it's just for the sake of clearness and certainty that we would then just confirm that a finding of non-compliance must first be made before the department makes such a decision. Chair, we again have also just we've amended the long title, and that is just technical amendments to ensure that we cross all our T's and dot our I's, and then also we have included a provision, Chair, where wherever you see the word SASCOC in the Principal Act, it will now be replaced with the expression Sports Confederation. And again, Chair, we are just being very pedantic, and we are ensuring that we are dotting all our I's and crossing all our T's. Thank you, Chair. I hope I've clarified everything. If there are any questions, I am available to answer them. Thank you, Chair. Thank you, honourable members. Thank you, colleagues from the department, and thank you, SAIDS.
Thank you, Arnold. You made this task very easy, but from the very onset, we appreciate what you have been doing to come together in order that in this day, we are not getting different opinions. What you have done, it was a noble idea of coming together. And now, as these members, we are appreciating your work, both of you, the staff, the legal advice from our parliament, and SAIDS department. You made this work to be very easy, even for us as parliamentarians. We appreciate this work. Honorable members, can I check that you want to say something after all this presentation of the three very important spheres, your department, your SAIDS, and our legal advice from department? That collective came with this product. Honorable Dennis, I'm very sorry. I'm still trying to cope with my flu, but I'm not that bad. Honorable Dennis.
Good morning, Chair. Morning to the Minister and all the department officials and all the other stakeholders, members. Thank you very much for the very, very brief, detailed information, explanations. I just want to ask Ms. Khan that right in the beginning, when she started, she spoke about, I think it's the Free State, or just before that, she said Katesa wanted the word sports, definition sports, to be included, and the department reckon it's not necessary. And then the next group, she made reference to the Free State group that wanted the Poppy Act to be included. And then her response was, it is the general law of application. So my question here is, why is she not putting in there also in the recommendation of the department that request also is not necessary? If that, I'm just asking if it is necessary to say it in that bold way or just say it is the law of application. Chairperson, I think I have two more questions. The other question I have was at the legal, at 17 section, I think it's under SARU, section 70C, section 17.7C. Just the question on whether legal reps will be allowed at the hearing. It's now with the appeals hearing board, whether legal reps will be allowed, and that ties in with my next question, Chairperson, of observers. That was an interesting point that the legal person have given to us. It's still open, I hear. The question I have in any observer, what is the purpose and the motive of the person coming? If it is allowed and that person is a legal person and there's a court case afterwards and so on and ends up in court, then obviously that people have access to that information. But the athlete itself, when appearing with this case and this appeal, if a legal person is allowed there, then I don't think observers should be allowed at that particular hearings or appeal hearings. And then just the question of clarity, Chairperson, there was in one organization who actually made, I can't recall now, who made a point that there are athletes, when they suspended, they move to another organization and they participate in another sports code, and then they also achieve all these awards. So I'm asking in terms of this amended legislation, if that is the scenario in South Africa and whether we are closing that gap, because it is unfair if an athlete, gets involved in doping, is suspended in a sports code, and then just is taken up in another sports code and then achieve international awards in the name of under South Africa banner as well. I just wanted clarity on that, if that is covered or necessary to cover, and whether it's the rules that will cover that or the legislation that should cover that. I just wanted clarity on that. But thank you very much. I'm very privileged to sit in this meeting and to learn all this information about doping, anti-doping. Thank you, Chairperson.
Thank you, Honorable Dennis. Can I give a chance to Honorable Adams?
Thank you, Chairperson. Good morning to you, Chairperson, and to all on the platform. Greetings to Deputy Minister, all protocol observed. Chair, from my side, we agree totally with you, to all stakeholders who participate in the exercise. We couldn't come this far without their assistance. As members of this committee, I must say, we acknowledge the work done this far. Keep up the good work. You made this committee very proud to set the goal for the finalization of the bill, which who has looked as a mountain before us, but we are almost there. Keep up the good work. I thank you.
Thank you, Honorable Adams. Can I take it back to the DG with your team and Arnold to answer these questions? Some you have reflected in some of the question that the Honorable is raising, but let's give it to you to reflect. You were clear what you have done. You accommodated what, but can I give it to you back?
Thank you very much, Chairperson, and thank you to the honourable members for the questions and for the comments. Chairperson, we note and we appreciate the comments from Honorable Adams. I note that she's made comments more than asking any questions for clarity. To come to the issues raised by Honorable Joseph, with regard to the issue of the definition of sport, you know, Honorable Member, we had looked at the definition of sport. We've got the white paper on sport that would define sport, it would define recreation, etc., so that these are two separate entities and how they are then delivered. But legal were of the opinion that let's not add too many new things into this bill. So let us just leave it as it is, to say there's no, we're not making any inputs here. We would then say grammatically or in the dictionary meaning, let that apply for now for the purpose of this bill. Because the moment you put something, you never know how it's going to be interpreted. For example, as the legal person has said, WADA raised the issue of republic. What does republic mean? And for us, we believe this was our act. So it's our act. When we talk about republic, we know it's the Republic of South Africa. So we didn't just want to put in any definition where somebody else has a different idea of what the definition should be. So that's why we left it as that. With regard to, you know, whether it's necessary to put the comment around the poppy, I think legal services will respond to that. With regard to the hearings, I think legal will also, and the observers, I'll ask legal to respond to that. In terms of the athletes moving from one pole to the other, to move away from, you know, not being identified or detected as not being clean, I think what SAIDS will respond to that, because they do have a tracking system. There is an athlete's passport that they deal with, so they will be able to say what measures are already in place and where it is also catered for, either in the legislation or in their own code of conduct, their rules, or their standard operating procedures. Colleagues, Chairperson, if I can hand over to our own legal services and then to SAIDS to respond to any of the questions. Benedict, I hope I hear, and Mr. Matet, to you.
Thank you, DDG. Through you, Madam Chair. Benedict, back again. My apologies for the poor network that one seems to be having this morning. I think the DDG has sufficiently responded to the question of the definition with regard to sport. And again, I reiterate the omission for the inclusion of reference to the POPI Act. As I've stated, that POPI is same as your Promotion of Administrative of Justice Act. These are laws of general applications. Whether you include them in this particular bill or not, you still have to comply with their particular provisions. And I've stated we do not want to conflate this particular bill by certain issues because of the experience we've also have had with WADA, with dealing with the to and fro. So it was a meticulous task of trying to also balance this particular contravening issues. So in this instance, we're of the view that even if we do not include reference to POPI Act, our law still dictates that you still need to comply with the provisions of POPI Act, and hence same was not included. Now, with regard to the question of a legal representation, the new amended clause, that is 17, if one were to read 17.3, it speaks to a party to an appeal to be entitled to a representation of his or her own choice. It does not necessarily say a legal person, but of a person of their own choice, which means that legal representation may be admitted. Again, the elaboration of these things we decided to leave them to the appeals board to prescribe the processes and procedures to be prescribed by the appeals board, and not to necessarily bring them into the bill. Again, I beg yours, again, also with regard to the question of observers, we know the submission and our draft as it stands. If one were to make, were to be to draw the attention to section 17 subsection clause 17 subclause 5, which reads as follows: a member of the institute and a member of the and a member representative from a national sports federation in respect of its member athlete shall be entitled to attend any hearing of the independent doping hearing panel or the appeal board. Also, because we had also sent the draft to WADA, they've also came back with this very same particular question, and our resolution was to the fact that an observer will be allowed both in the independent doping hearing panel or as well as in the appeals board. I trust that answers the question. If I missed one, please assist me. Thank you.
Thank you, Benedict. Any other input from our legal advisor, Arnold? Yes, Arnold.
Hi. So Benedict has quite correctly, and DDG Sumayakana has quite correctly stated that with regards to the definition sport, there is no need to define it. The meaning is clear in its context. Poppy, we won't insert it because, one, that piece of legislation would apply regardless. It is a law of general application, but two, the Principal Act does not make a reference to it. So to define something that is not referred in the Principal Act would serve no purpose. It's one of the rules of drafting. You don't define that which is not used in the legislation, but the fact that the Act does not make use of the word should not cause alarm, because constitutionally the department says anybody who deals with any information of anybody would be bound by Poppy, and they would have to protect the personal information of anybody. And then with regards to representation, legal representation, we have included a provision in section 17 which confirms that a party may be represented by anybody of their choosing. And this is dealt fully in SAID's rules, but I think it is a standard that we accept in South Africa, that you can be represented by whoever you choose. It need not be a legal person. And I think that touches on fairness and justice. Chair, honourable members, with regards to the question of observers, we do have it in the draft of 17 at the moment. However, if the committee would give me time to just double check, but preliminary, I am of the view that we should remove the reference to observers. And the reason why I'm saying so is because SAID's rules deal fully with regards to the observers. And I don't want us to be accused of overburdening our section 17. And if I look historically at one of the comments that WADA had made, and I think this was back in November when they made a comment on the introduced bill, and Chair, I will double check, they had indicated that we should remove the reference to observers as it's contained in SAID's rules, but I will double check, Chair, honourable members, just to make sure that whether we remove or whether we keep it. But as far as my memory recalls, they had made a comment or a recommendation that it should rather instead be removed, Chair. I think that covers everything, Chair. Honourable members, thank you.
Thank you, Honourable Sates. Any intake on the questions?
Good morning, Chair. From the SAID's input, I'll hand over to our legal manager, Wafika Beg, to provide her input.
Thank you,
Thank
Khalid.
you.
Morning, Chair. Morning, honourable members. To add to what DDG Khan, Mr. Benedict and Ms. Arnold has added with regards to observer status in Article 8.1.2.5 of the SAIDS rules. It is covered there, and I'll also read to you what the clause states. It says WADA, the International Federation, and the National Federation of the athlete or other person may attend the hearing as observers. In any event, SAIDS shall keep them fully apprised as to the status of pending cases and the result of all hearings. In practice, when we have a hearing of first instance, we always inform the National Federation that there will be a hearing and on which date, and then we invite the CEO or the president to attend if they wish to do so. Then with regards to Honorable Joseph's comment on athletes banned from competitions and then competing in other competitions, SAIDS's rules deal with violations where athletes violate the period of ineligibility or provisional suspension, and that is covered under Article 10.14.3. So if they are caught competing in other competitions, we then provide them with further that we extend their sanction. Alternatively, if Bodybuilding South Africa was implying, which I think they were, with regards to bodybuilders that compete at their national champs, then are banned by SAIDS, and then they compete in other bodybuilding competitions. So that's a different situation, because we have to look at where does SAIDS under the code and the rules have jurisdiction to ban athletes. So sometimes bodybuilders will then look at competitions that are not sanctioned, organized under government, or that fall under the jurisdiction of PBSA or SASCOC's regulations. So there's a loophole there, and unfortunately, SAIDS and under the code, we do not have any powers to act if these competitions are not sanctioned by government, etc., or SASCOC's members. I hope that answers all the questions. Thank you.
Thank you so much. I can't see any other hands, but I want to say with your Wafika department and our Arnold, you must, after this meeting, talk to each other about this thing of observers, as Arnold was having the input, which is different from the department and from you, SAIDS. That's why now I'm saying that we are going to break and then we'll come back at 2. I'm aware that by 3 we're having a plenary. So we're giving a chance that go and polish, as this last comment of mine is saying, that you must come together in order that when we're coming back with the correct version, in order that we must come and consider the deliberation and see, and we come and adopt the participation of the public on this bill. And then we are coming back at 2, hoping that you have enough time. I know you have been not sleeping. If I can tell you, I was anxious. I was sitting here where I'm seated, thinking that was starting at 9. And I was calling, Bulelwa, where are these people at 8? Where are they? Why I'm just alone? No one is accepting. So I'm suspecting the anxiety of us all that this work must come to the finalization. I don't have any other input, DM.
No, Chair, thank you very much. And once more, thank you very much to honorable members. I think the word today will always be the thanking part. We really have no words. Just to say, Chair, you know, some people always wonder why South Africa is such a wonderful country. It's things like this. When we have to stand up and show up as South Africans, we do it, and we do it with aplomb. That's exactly what we have done right now. I'm sure we're going to have the best amended bill, and WADA will have nothing to say. I'm sure we are on the right move. Thank you so much, Chair.
By those words, DM, I'm suspecting this is as I'm going and as I retiring. There was somebody, DM, called me. Why no one is mentioning that we are retiring? No, I was telling this person, people who were mentioned, they were the ministers who reflected and deputy ministers. I've started to tell this committee and these entities, all our entities, they know that this is my last chairing this committee. Those who are not going to come back in any program, I did indicate saying that today, this is my last chairing committee because I'm voluntarily retiring. I'm not retiring because the lists are out. I've started to say in the beginning of the year, Honorable Mteto was saying, you were not joking. I was not joking. But this experience, I know I was once having the bills and interviews in early days of CGE. They were not that hectic like what we're doing. Even myself, I'm wanted that our legacy as this committee with this chairperson who's taking retirement must be like this. I'm very proud of all who have doing this, let alone our committee members. They were meeting Fridays, they were meeting Mondays. It's just unusual. And now, DM, as you having the program, as from Friday, we'll meet until Sunday with other things which are of your department. I'm taking also this, saying that these legal gurus, they were becoming just South Africans, not wanting that anything wrong must happen. We nearly shocked that we were not going to have our flag flying when our world champs were winning the rugby. And now the athletes and everyone, we are proud of this flag. I thank you. Now we adjourned until 2:00. I thank you.
Long live Mashlomo. Long live.
Thank you, Lord.
Yeah, thank you to all.
Thank
Only Member
you.
Mteto was coming back. Only Member Mteto was coming back. He's the only one.
Yes.
How do you know? How do you know that I'm coming back? Hey, Joseph.
I saw the list. The list leaked out.
No, with us.
I'm just joking. I'm just joking.
The deployment of committees is another thing. We will wish that the continuity of two members whom I know, I'm confirming, and you have seen the list, Honorable Adams, Honorable Zondi, but the deployment is another thing. We'll never know whether they will be continue to be in this, but in a lighter note, the meeting
they will be back. Thank you, Chair. I'm sure they will be back. Thank you, Chair.
The meeting is adjourned.
See you later.
Thank you.
Thank you, Chair Malibongwe.
Madam